The contract that you didn't read before you signed it is already working against you. You don't really lose your breach of contract case in court. You lose it when you sign your bad contract in the first place. Before you sign another contract or send one, watch this. Hi, I'm Dustin Lee. I'm the founding attorney of Ascend Legal Solutions. I'm a business law attorney here in the state of Texas. I have seen and worked on more contracts over my 17-year career than I can possibly count. I've seen transactions with good contracts, bad contracts, and no contracts at all. I've seen the same common mistakes come up over and over again, the types of mistakes that cost business owners time, money, and cause relationships to go sideways. In this video, I'm going to run through 7 of the most common contract mistakes that I see and what real problems that they could potentially cause you. If you stay to the end of the video, you'll have a clear picture of where the most common types of contract risk are that I see. Now, everything in this video is for educational and informational purposes only. I'm not providing any legal advice, tax advice, securities advice, financial advice, or any other type of advice. And nothing in this video creates an attorney-client relationship. First, the most dangerous contract that you use in your business is probably the one that you got for free. What are we talking about here? We're talking about free online contracts that you just found randomly, things that you paid a very low cost for or no cost for as a DIY contract, or things that you used AI to generate. A business owner logs on to a random website that they found online. They download a template. It says Texas non-disclosure agreement or something like that. They don't change anything. They just fill it in with the parties involved and call it a day. Why is that a problem? Well, obviously because generic contracts are generic. They don't serve your business. They don't serve this particular transaction. They're not customized in any way to protect you and your business. Key provisions are often missing or very vague or ambiguous, and you don't know enough as a non-lawyer to correct those things, and you just fill out the template and call it a day, which leads to extreme contract risk down the road. Now, another key point here is that courts are typically going to look at exactly what's on the page when they're interpreting a contract. They're often not going to look at what the parties actually intended or what the parties discussed in advance, especially if there's a clause in the contract that says that all of those things we discussed before the contract, those are not a part of the contract. So especially in that case, the court is going to look at what's on the 4 corners of the contract to determine what the parties' obligations are. And if the free template contract doesn't discuss some particular very important issue, you don't want to be stuck with that template contract. The template contract doesn't necessarily protect your business, and it may even create more problems for you down the line. Mistake number 2, not clearly defining the scope of work. One of the most litigated lines in a service contract isn't some little piece of legalese that's buried on page 10. It's the actual scope of work that you've written up, and now you and your customer have a complaint or dispute about it. Well, people will bring in contracts where the scope of work is something like IT services, or website design, or marketing support. And in there's no deliverables, there's no deadlines, there's no KPIs or criteria. There's really nothing that describes with detail what the actual work is going to be. So both parties sign the document thinking they're aligned, and it turns out they're not. Why is this a problem? Well, if you and your customer have different expectations and the contract doesn't clearly address those expectations and what they should be, then you're going to have a dispute with your customer. So, for example, if you put down general consulting services and the customer was thinking that they're going to be getting services A, B, and C, but you really only meant to provide services A and B, well, now you've got a dispute over your contract. Vague scope language is one of the key critical factors that you see for contract blowups, litigation, fee disputes, or just having to do a bunch of work for free to keep your customer happy. It's something that you really want to avoid. The more specific the scope is, the less likely it is there's going to be an argument about it. Think of it this way. If the contract doesn't define what done really means, your customer's probably going to decide that for you. Mistake number 3, leaving out payment terms entirely or just putting them in a very vague way. If your contract doesn't say when and how you get paid, you might not. So you may be surprised thinking that net 30 or due upon receipt is something that is super clear. But in fact, if you don't have a detailed payment provision as to when and how to get paid, as well as the consequences for non-payment, you've really given your customer an incentive to push the limits on that or maybe even not pay you at all. Now, why is that a problem? Obviously, if the payment deadline is in there, then you don't have necessarily a problem with that as long as it is something that is clearly triggered, like due upon receipt. Well, how do we prove that they received it? And then what happens if they don't pay it? Does the contract tell us what happens next? Tell us what the procedure is for disputes? Does the contract tell us about the late fee or potential recovery of attorney's fees? All of these things are really important to have in there. Without clear terms and consequences for non-payment, you're essentially pre-litigating every payment dispute whenever it comes up, when you could just have a contract to handle all that for you. So essentially, your payment terms are your enforcement mechanism for your contract, and they need to be specific enough for you to actually be able to enforce the contract. Contract that's vague about collection makes collecting really hard to do, and that's something, trust me, you don't want. Mistake number 4, no termination clause. Now, most contracts are going to tell you about the starting point, but a lot of them don't actually tell you about the ending point. I have contracts come in all the time where there's no termination clause and nothing about what happens if one party or the other breaches the contract. Even the ones that do, it may be just something very basic like a little one-liner. It may only address termination for cause, but not what happens if there needs to be termination without cause or just for any reason at all. In addition to that, there's a lot of particulars that are often not built in, like notice requirement, opportunity to cure, problems for what happens if this needs to be enforced. Why is that a problem? Well, obviously that's a problem whenever a dispute arises and there's no clear exit for one party or another. It's also a problem if there's no enforcement mechanism, and potentially you may actually want to have an agreement drafted where there is an ability for the other side to cure the breach, because it's going to be far more expensive to get somebody else in here to fix the issue. What's at stake, or what are we looking for here? Well, we're looking for a clear termination clause that's going to provide information about what's going to happen if there is a dispute, how that dispute potentially could get resolved, or if it can't get resolved, how do we terminate this contract, and also what happens after termination. So as you can see, the exit terms of a contract matter just as much as the entry terms, so to speak. A lot of times people don't feel the need to write those in, and it can be a big problem. Mistake number 5, no dispute resolution clause. If your contract doesn't have a dispute resolution clause, well, now your dispute ends up in court, which is pretty much the most time-consuming and expensive way to resolve a dispute. But even if it has something in there like an arbitration clause or a mediation clause, in my experience, they often are not detailed enough to actually provide a clear path forward to a dispute resolution, and potentially can even cause more problems than they're solving. For example, if the contract says, well, we have to mediate any dispute before a lawsuit is filed, then it doesn't say anything else. Well, how do we pick the mediator? What if the sides don't agree to a mediator? Do we pick a panel? Do we each put in 3 names and then pick one out of the 3 names? How exactly does it function? In addition to that, leading up to the mediation, is there going to be any exchange of documents or information to make this a more productive conversation, or are we just going in blind? Is there a timeline set? How long do we have to mediate this dispute before a lawsuit can be filed? And what happens if somebody refuses to mediate? These are the types of things that often are silent in your little one-liner mediation clause saying, hey, we'll promise to mediate before we go to court. Why is this a problem? Well, obviously it's a problem if you don't have any dispute resolution at all, because you're ending up in court, which is the most expensive and time-consuming way to work things out. But in addition to that, if you don't have a clear roadmap or path built into your dispute resolution clause, it might not be all that helpful, and it might not end up saving you any time or money, and that's really the whole purpose of a clause. What does this clause really do? Well, a carefully drafted clause like this can require pre-litigation negotiation, mediation, arbitration, the specific terms, path, and process for each one of those things, and potentially could end up saving one side or both sides a lot of money if a dispute ever does arise. So potentially a dispute resolution clause can determine whether this dispute costs you thousands or hundreds of thousands of dollars, and obviously you want to take the route that's least expensive for you. Mistake number 6 is missing or limitation of liability or disclaimer language. The contract may cap your fee, but it may not cap their damages if something pops up, and you certainly don't want to be on the hook for more than you expected. Your contract determines a price that you get paid, but then if something comes up, some problem happens, and the other side sues you for, say, bad service or bad products or whatever, you may not be on the hook just for what they paid you. You may be on the hook for consequential damages, punitive damages, any sort of additional damages on top of that that you may not have been on the hook for if you had carefully crafted your agreement. So your potential exposure on something like this can be significantly more than what you were actually paid under the agreement. Why does this matter? Well, think about it like this for something like consequential damages. Let's say your customer communicated to you that they need this particular product by the deadline because they have already got it resold to somebody else for 5 times as much. And your contract doesn't have any limitation of liability, any limitation on consequential damages. Let's say you don't hit that deadline, and now you turn around and you get sued by your customer for 5 times as much because that's how much profit they were going to make on the deal. Contracts commonly leave out disclaimers and limitation of liability clauses, and it leads to potential significant damages for the other side that far exceed the amount that you actually got paid under the contract. You really ought to set a clause like this in accordance with your actual risk profile and not just some template language that you found. So a limitation of liability clause, even if you have one, if it's not properly drafted, is sort of giving you a false sense of security when really your potential exposure is far more than what you expected. Mistake number 7 is vague or ambiguous language just in general throughout the contract. Two of the most expensive words that I have seen are things like reasonable or as necessary. Now, obviously, there are times when you're going to have to build in some sort of reasonableness into a contract, and that's not really what we're talking about here. We're talking about here in cases where you have the opportunity to put in something specific, and instead you choose to put in something general or ambiguous or vague. You really want to be able to craft your agreement in a way that is the most specific as possible, because that sort of general language, that vagueness, that ambiguity can really come back to bite you. So in a case where you need to write reasonableness, obviously there's a time and a place for that, but most of the time you're going to want to be as specific as possible. Now, why is this a problem? If you end up in court with a contract or in an arbitration with a contract, and that contract is vague or ambiguous, that vagueness or ambiguity may end up being resolved in the other side's favor whenever you could have just drafted a clear and precise contract to start with. So as you can see, vague language typically doesn't protect one side or the other, and it's a very good opportunity to open up the door for disputes. Now, this is not a complete and exhaustive list of all the common contract problems. There's more than you could really count. As you can see, because of this, I do recommend that if you're able to, you get an attorney to help you out with something like this. So if you have contract issues, you should contact a qualified business law attorney in your jurisdiction to help you out on your contracts. Unfortunately, from time to time, something may just happen, even if you have an incredibly strong contract. And these are things that all can pop up in just normal, everyday contracts that both parties sign in good faith that end up in a dispute later. However, most of these things are preventable. In fact, the ones that I've talked about in this video specifically are very preventable in most cases. Now, if you're using a free budget DIY template contract or something that you got AI to output without really giving a lot of thought to it, that may be a contract risk that you have, and we actually have a different video talking about that. I'll see you there. Thank you all for watching.